Um, so today, guys, what we're going to do is I'm going to cover three topics. They're three kind of miscellaneous topics. The first topic is when dealing with month-to-month leases. The question arises. Can we cancel a lease on 30 days notice, or do we need a do we need to go a full calendar month? And if we must go a full calendar month, well then what does a full calendar month mean? And guys, this kind of finds application mainly for rental agents, but I think it's also important for sales agents to understand as well, because if you're dealing with a rental agreement, especially if you're doing the management, you need to understand it's really, really important. There's serious consequences to getting this kind of thing wrong. When your landlord instructs you to give notice to a tenant to vacate, and likewise in sales, you need to understand that if you sold the property and the property is a tenant and your buyer is going to occupy the property, and we need to give notice to the tenant and you tasked with doing that, again, it's really important to get this right, because again, there's quite quite serious consequences in order in not getting it right. So as I indicated earlier, the question is, if you must go a month's notice, well, what does 1 month mean? Does it mean 30 days notice, or does it mean a full calendar month? And if it means a full calendar month, well, what is a full calendar month? What does that actually entail? So the first place we need to look at is the Rental Housing Act. And the Rental Housing Act has a provision which is Section 5.5 of the Act, and it reads as follows. If on the expiration of the lease, the tenant remains in the dwelling with the express or tacit consent of the landlord, the parties are deemed, in the absence of the further written lease, to have entered into a periodic lease on the same terms and conditions as the expired lease, except that at least 1 month's written notice must be given of the intention by either party to terminate the lease. So let's just talk about this generally first of all. So this is where you have a fixed term lease agreement. So your fixed term lease agreements, for example, for a period of 12 months. What the Rental Housing Act provides in this section is, if nobody does anything whatsoever, nothing happens, then the after the expiry of the fixed term lease agreements, let's say your fixed term lease agreement expired at the end of March. From the 1st of April, you're deemed to have entered into what's called a periodic lease. Okay, and that lease will sort of continue for the foreseeable future, unless one party cancels the agreement by giving 1 month's written notice. As an aside, and just to remind you guys, and I think I dealt with this a couple of webinars ago. As an aside, just also remember you've got the 40 to 80 day notice. So if you, for example, if you have a fixed term lease agreement and you want your notice, you want your lease to expire, as a landlord, you need to give your tenant notice between 40 and 80 days of your intention for the lease not to continue. And this is really important if we consider this as a general discussion. It's really important because if I'm a landlord and let's say, for example, my lease expires at the end of April, right? And I want the lease to terminate. In terms of the Consumer Protection Act, between 40 and 80 days prior to expiry of the notice, I must actually give my tenant a notice to say this lease will expire, and it's a very subtle point of law. This, if the 1st of May arrives and you say to me, "Great, Marius, the lease is expired, you must now move out," I may turn around to you as a tenant and I may say, "But you didn't give me my 40 to 80 days notice. So no, I'm not going to move out. Now we're on a month-by-month lease agreement, and now you must give me 1 month's notice." And of course, as you'll see coming up, that 1 month's notice can't be given on the 1st of May. I must now wait until the last day of May to give notice for you to move out at the end of June. So you see, by making a small mistake, we're actually going to lose 2 months worth of time. And if you're in a sales situation, it's going to delay our transfer by 2 months. And if you're in a rental situation and you've got somebody else moving in, you can imagine the mayhem that's going to create. What's also really important, and again, as a general principle, as a general practice, good conduct type of practice effort, whenever you're dealing with lease agreements, go and take the lease agreement and read it. If you're unsure, give it to us. Let us read it for you, because sometimes you might have a lease agreement that says, in the event this lease agreement continues after expiry of the fixed term, and then it continues on a monthly basis, the lease can only be terminated by giving 2 months notice. Right. So some lease say the legislation says a minimum of 1, but it could be 2 months notice. It could be 3 months notice. And if you misread these lease agreements, or you don't look at the detail of it, you end up in a scenario where you give 1 month's notice and the tenant says to you, sorry, 1 month's notice is not sufficient, it's defective. And then the question is, well, can I simply say, sorry, it was supposed to be 2 months and give another month? Or must you start again and give 2 months? So in other words, if the argument is, well, you give 2 months and you were supposed to give 2 months, you go 1 month, now let's give 2 months, now you're giving 3 months in total. And again, you're running yourself into a rather precarious situation. And again, please understand that the law is such that the tenants are protected. So if the tenant turns around to you and says, listen, your notice is defective for whatever reason, I'm not moving out, please try again. Please give me the correct notice from the start. You might be upset, you might be angry, you may argue your point, but at the end of the day, you can't get a tenant out, and there's nothing in our law that's going to allow you to get him out, on an urgent court application basis. You must start the process, go through the PI legislation. It's going to take you 4 to 6 months on an unopposed basis. So this is why it's so important to get this right. So of course the question then arises, well, if it's 1 month's notice, well, what does 1 month mean? All right, and there's a case, Luongo versus Perth Park Properties. It's a 2018 case, and the facts of the case are really not important for our purposes. But what is important is that the court in this case had to interpret the Section 5.5 of the Rental Housing Act in dealing with what does 1 calendar month's notice mean. And what the court said, first of all, and there's 2 points to this. The court said, first of all, that 1 month's notice is not 30 days. So in other words, if I want to give a tenant notice today, I can't give notice on the 9th of April and expect them to move out on the 9th of May. So 1 month's notice is not 30 calendar days. 1 month's notice means 1 month, right? So when giving notice to a month-to-month lease, it's important that we look at Section 5.5, that we must give 1 month notice. And of course, the second part the second part of the judgment in this case was, what does 1 month mean? And what the court said 1 month's notice means is you must give notice on or before the last day of the month preceding the month in which you want to terminate the lease agreement, right? So that's actually relatively confusing to look at on that basis. So let's have a look at an example. Sorry, I'm jumping ahead here. Okay, so the example is this. If you want to terminate a lease agreement on the 31st of October, you must give notice on or before the 30th of September. So in other words, we're giving notice on the last day of the preceding month in which we want to terminate. We want to terminate in October. The last day of the preceding month is the 30th of September. If we give notice on the 1st of October, it's too late. And I think this is the most important part of this section of the talk. The 1st of October is too late. And yes, you may have gotten away with it in the past. Maybe you gave notice on the 1st of October and they moved out on the 31st of October. Pick up on this nuance of law. And I have had very practical examples of cases where landlords, property managers have given notice on the 1st of October and the tenants have said, sorry, you are too late. You're too late. I will now only, my 1 month, if you give me notice on the 1st of October, my expiry period is the 30th of November. Not the 30th, not the 31st of October, the 30th of November. So in other words, you give me 1 month. 1 month on the 1st of October means 30th of November. Sorry about that. So, and again, this is why, guys, it's so important that we kind of get this right, and we look at the detail to make sure that we comply with the section, we comply with the correct interpretation. Okay, guys, that's the issue of 1 month's notice and giving notice on lease agreement. The second issue that I want to discuss with you is late rent. Can interest be charged? If you can charge interest, what interest, what can be charged? And this is an issue that we dealt with arising from a practical situation where we asked the question, what rent can be charged? The practical situation was obviously that a landlord was charging tenant an particular interest rate, and the tenant was saying, listen, well, you can't charge. The other issue that arises here is, can you only charge interest? Can you charge interest? Can you charge some kind of other penalty? And how do we deal with this question? What's the right answer? And understanding that, again, we've got the scenario where tenants tend to hold the power, right? And if you're a landlord, if you do rental management, you'll know what the frustration is. Tenants routinely pay you late. They routinely pay you on the 7th. They routinely pay you on the 10th or the 12th of the month. Despite the fact that you ask them to pay on the 1st, your contract says in the 1st, people, it's a frustrating experience, and we want to punish the tenant. We want to try and get this bad behavior out. And I mean, even with interest, I'm not even convinced that you're going to get it right. But it's I suppose one need to just understand exactly what our rights are. While I'm on this topic, guys, there's also a common misinterpretation or misunderstanding of the law. Sometimes people are of the view, especially tenants, mainly because it's convenient to think this, but they believe that the law allows them a leeway to pay until the 7th. So it doesn't matter what your contract says. Tenants believe that there's a law somewhere that says you can pay on the 7th. That's absolute nonsense. There is no such law. There's nothing in law that says that whatsoever. It's I've never come across it in my career. So let's look at the National Credit Act first of all, because very often when we're dealing with these lease agreements and interest, we say, hold on, what does the National Credit Act say? What does the National Credit Act say about interest? And it's important to understand that in terms of Section 8.2b of the NCA, basically, it provides that an agreement, irrespective of its form, is not a credit agreement if it is a leaseable movable property. So what this tells us is that a lease agreement is not a credit agreement, and therefore is not covered by the National Credit Act. Okay, and that's good insofar as it goes. But does it help us? Well, it will help us, and I'll show you in a slide or two coming up. So just understand that the lease agreement is not a credit agreement. Okay, and therefore the provisions around interest rates in terms of the NCA don't apply. We do also have the Rental Housing Act, which has its say about this issue. And what the Rental Housing Act is, actually not the Rental Housing Act, to be more precise, it's the Unfair Practice Regulations, which are published pursuant to the Rental Housing Act. Guys, if you're dealing with lease agreements, if you're doing rental management, a lot of people don't seem to know that you have unfair practice regulations published pursuant to the Rental Housing Act. People don't even understand these things exist. So if you're dealing with lease agreements, if you're dealing with management, please drop me a mail and I'll send you a copy of these unfair practice regulations. They're not very long, but I must say they do actually create quite good reading. So, for example, and as an aside point, and one of the things that the rental unfair practice regulations say is that if you have a lease agreement and it's not signed by one of the parties, but the tenant moves in and he pays rent, it's deemed to have been signed. If the landlord allows the tenant to move in and the tenant hasn't signed the lease agreements, it's deemed to have been signed. So there are some useful things in there. But back to our point, what the lease agreement, what Section 3C1 says, a lease agreement must exclude any provision which imposes a penalty for late payment of rent, whether or not the penalty takes the form of an administrative charge or any other form other than interest. So in other words, what this is saying is, you can't charge 500 Rand late payment fee. You're not allowed to. Okay, you can't charge any kind of late payment fee, save for interest. So flat fees, similar fees, all those things. And I came across a scenario during the course of last year where we wanted to sue somebody for arrear rent, but the landlord had been charging 500 Rand a month for months on late payments, and we excluded it. We didn't sue for it because you're not allowed to, because the law doesn't allow it. So the other thing we must understand is this issue applies only to residential leases, because this is the Rental Housing Act, right? Which is the Residential Rental Housing Act. It doesn't apply to commercial lease agreements. So what the Rental Housing Act tells us is, yes, you can charge interest. You can't charge another form of penalty, but yes, you can charge interest. Okay, so that's kind of the next step in understanding this process. So I've jumped a slide here. Okay, so interest is specifically allowable and can be enforced on residential lease agreements. So in calculating the interest, you need to say, well, how do we determine what the interest is? It can't be unreasonable, it can't be excessive. We don't know there's no real definition for reasonable. Okay, but we now need to go and look at the rental house at the National Credit Act, because the National Credit Act will give us some kind of indication. And of course, before we do that, it's important to say that, again, guys, if you're dealing with a lease agreement, go and read your lease agreement. What does your lease agreement say? We now know that you can't charge a 500 Rand penalty. You can charge interest, but you can put interest. Maybe your lease agreement says interest. Maybe your lease agreement says, in the event of late payment, interest is charged at the rate of 2% per month. Okay. So that we need to have a look and have actually a look at the agreement first. So what the National Credit Act says, the National Credit Act allows for a maximum prescribed rate of interest being capped at 2% or 24% per annum. So what I'm not saying is the National Credit applies. We know it doesn't apply. What we're saying is we're going to determine what is reasonable. What can you put into your lease agreement? What's reasonable? And if you make the comparison with what's reasonable and what's allowed in terms of the National Credit Act, and we say the maximum prescribed rate of interest is currently capped at 2% per month or 24% per annum, then we can say, well, that's reasonable as a maximum rate of interest. So if you want to have in your lease agreement, Mr. Tenant, in the event that you're late on your rental, the maximum rate of interest the rate of interest we're going to charge you for late rental is 2%, and that 2% will accrue from the first day of the month or the second day of the month when it's late, then you can stipulate that in your lease agreement. And again, when we're talking about interpretation, we must go and look at the lease agreement, see what the lease agreement actually says, to try and make a determination. The other factor we must look at in terms of interest rates is the Prescribed Rates of Interest Act. So people don't know that there's this piece of legislation, and they don't even know it exists. But if I have an agreement, and the agreement does not provide for interest at all right? So let's say your lease agreement is silent on the rate. We haven't applied the 2% per month. It doesn't say anything in the agreement. It's completely silent in the lease agreement. Well, what can we do? Can we still charge interest? Yes, we can. We can look at the Prescribed Rate of Interest Act. And the prescribed rate of interest is calculated by observing the repay rate at the time the rental became due and then adding 3.5%. Okay. So, in other words, the current prescribed rate of interest rate is 11.25% per annum. And what they do is they change this every now and again. They publish a notice in terms of this act, and they publish this currently 11.25%. How do we apply the prescribed rate of interest? Well, what we do is we quite simply, you have to place your buyer in breach. So it's called placing your buyer in mora. So you're not your buyer, your tenant, and this applies to any contract which doesn't deal with interest. So if someone owes you money, whether it's arising from a sale agreement, a rental agreement, whatever it might be, if I place the buyer, the tenant in breach, so I look at my breach clause and I say, great, I haven't paid your rent. I'm now going to give you 20 business days notice to remedy your breach. If they don't remedy the breach in the 20 business days notice, I accrue the right to now charge interest at 11.25%. So from the date the demand became due, I can now start charging the interest. So of course it's in your interest to get that demand letter out as soon as possible. Of course, the better solution is to put the rate of interest into your agreement. And as we've seen, the reasonable rate of interest is going to be comparable to the NCA, which is 2% a month. And 2% a month, it's quite a bit. It's a good rate. All right. The last topic that I want to cover is deregistered companies and property transfers. So what I'm talking about here, guys, is if you're dealing with a buyer or a seller who is a company it's a company or closed corporation, what we need to do is we need to make sure that the company has the correct contractual capacity to enter into the sale agreement to sell or buy the property, right? So what this means is that, like an individual, a company has to have a legal capacity. It has to have legal ability or legal contractual capacity to enter into an agreement of sale in order for that agreement to be binding. So what this translates into is your company in business? Is your company deregistration process, or is it deregistered? So in terms of Section 82 of the Companies Act, what the CRPC can do is deregister a company, and it's deregistered for a number of reasons. One, failure to submit your annual returns for 2 more years, or appearing active for at least 7 years, where no person has demonstrated any reasonable interest in its continuance. So with the advent of the New Companies Act, what actually happened was that you had thousands of companies and closed corporations. I mean, literally thousands. And many of them, because owning a company or closed corporation is a national sport in this country, many people form companies, they do something that they don't do anymore, or they form it because they want to do something. So literally you've got these companies hanging around the company's office, but they're doing nothing. So what CRPC did was they said, listen, and this is in terms of Section 82, they said, if you don't pay your annual subs for 2 or more years, or we can see your company is not active, we're going to deregister your company, right? So this is not related to property. This is a general process of deregistration. So what they do is, if you don't pay, they put you into deregistration process. So the ordinary status is in business, and if you do a deeds office search on a company, right? I mean, not deeds office search, a CRPC search. In the top right-hand corner, it's going to say in business, or it'll say deregistration process or deregister. If it's in business, you're good to go. The company's in business, it's got full contractual capacity. The company can contract in its name, it's all good. If it's deregistered process, what it means is you haven't paid your annual subs, and CRPC is in the process of deregistering your company. So in other words, if you do the CRPC search, you see the deregistration process, you must immediately go to your seller or your purchaser and say, if you don't act now, you will be deregistered. All right. Because the next step is, if you don't act, the company actually puts you into deregistration. So you're deregistered. And what this means is that if your company or closed corporation deregistered, you no longer have a legal persona. You're not able to trade, enter into agreement, take legal action, and you basically have no contractual capacity whatsoever. So this is why it's important. This is why I'm raising this issue, because again, we go to all that hard work. We find the seller, we find the buyer, we find the property, we market it, we run up and down, we take 20, 30, 40 people through the house, we deal with all their nonsense, we spend time on our cell phones, our petrols waiting outside, and then we conclude the deal, but one of the parties pulls out because they don't have the legal capacity to enter the agreement, and one of those companies is one of those parties is a company. It's the same as checking the marital status of your individuals. This is the same thing. So what I'm suggesting to you is do a CRPC search and check whether or not the company is in business. If it's in deregistration process, act. If it's in deregistered, again, act. So how does this affect immovable property, right? So the legal position is, if a company is deregistered, all right, what it really means is that the company has no legal persona, and all assets, including immovable property of the company closed corporation, are then transferred to the state as bona vacantia. And of course, in practice, they don't actually get transferred. It's just known as, it's forfeited to the state. It's bona vacantia. So bona vacantia it's Latin for vacant goods or ownerless goods, and it's a legal proposition that prevails where there's no clear owner of the property. Okay, so the question is, well, what do we do? So I've already said that if your company is deregistered or in deregistration process, go to your seller, your buyer, and say, guys, take care of this before we go any further. All right. And also understand that a sale agreement entered into by a deregistered company is not enforceable. So in other words, if I'm the buyer and I buy a property from a seller, and the seller's a company and that's deregistered, I can turn around to that seller and say, Mr. Seller, this is not a valid agreement. This agreement is not valid, and I'm going to walk away. Okay. So what do we do about it, right? I mean, and what's the kind of solution? I think I jumped ahead. So what we can do is we can re-register, and again, guys, let me just be clear: when you deregister, your assets are bona vacantia, but they don't actually get transferred anywhere. In fact, the truth of the matter is absolutely nothing happens, and the state has never ever taken anybody's property as bona vacantia. Never. Well, not that I'm aware of anyway. So what do we do, right? If your company's deregistration process, go and file your subs, get it back into business. If you deregistered, Section 82(4) of the Act says that any interested party, not only the shareholders, can apply to reinstate the company. So you need the consent of Treasury and the Department of Public Works. And there's a pretty much this happens absolutely all the time. So there's a set and well-known procedure for this. It takes 3 weeks. It used to take about 6 weeks because there was at one stage a requirement that you had to advertise in the government gazette and a local newspaper. Those requirements are now gone. So yeah, upon re-registration, the rights and liability of the company are reinstated to the company. And in fact, there's a case. There's a Supreme Court of Appeals case which was decided in 2013, Godoma Trading and Noble Crest, where the court actually made a pronouncement on Section 82 for the Act. And what it basically said was, if you entered into agreement to sell and you were deregistered at the time, when you are restored, when you re-registered, any acts performed by the company closed corporation during the period of deregistration will be retroactively validated as if deregistration had never occurred. Okay, so what this means is, if I enter the agreement of sale as a purchaser with a seller who is a deregistered company, I can walk away from the transaction. But if that company goes and re-registers in terms of the re-registration process, well, hey presto, everything becomes okay. All the ills are cured, and the agreement is now binding on the parties. So again, the conclusion here is that the defect can be cured, but the bigger lesson to be learned is don't put yourself in that situation. List the property, do a CIPC search, make sure they're in business. If they're not, go and act and take steps to remedy it. This is the kind of thing that's a little bit obscure, perhaps. Doesn't happen, but it certainly has been known to happen that people walk away from transactions. And as I was saying earlier, certainly what you want to be is you want to be in a position whereby you haven't done all the work and you don't earn your commission because of some simple mistake like this. The question is, what is the responsibility from the seller side if he has not disclosed the terms of the lease agreement and agreed vacant occupation? Well, the seller is going to have a problem, because in terms of sale agreements, the most sale agreements provide for vacant occupation on registration or transfer. So the buyer is also entitled to transfer within a reasonable time period of complying with their obligations arising from the agreement. So if the seller doesn't disclose or can't get the tenant out, it's well, from a practical situation, we can't transfer the property. From a legal situation, there may be damages, and the buyer may be able to put out the property. And again, guys, this is really where it's important to do your property due diligence. You're going to sell a property. Get a copy of the lease agreements, go through it, send it to me. I'll go through it for you. Let's make sure that we know when this lease is going to end. Let's also make sure that we understand whether or not and let's say you do a deal and the lease is going to end at the end of June. So great, we sell the property now, May, June, great. We can cancel. We can have the tenant can be out, but we must make sure that there's no right to extend that lease. Because if there's a right for the tenant to extend the lease, then we must do an addendum to remove that right. So Sharia compliant landlords don't charge interest. Yeah, I mean, the question is, how about Sharia compliant landlords that don't charge interest? Well, if you want to be Sharia compliant, well, then you can't charge interest, right? You simply can't charge interest. Then you don't charge interest. Unfortunately, the rental housing regulations don't provide for Sharia compliance, so that doesn't mean you can simply now go and charge a penalty. It's interest or it's nothing. Unfortunately, but also remember, not that it applies to this, but there are Sharia compliant investments, Sharia compliant banking accounts. But yeah, I think that Amanda, the real answer to your question is, then if you don't want to charge interest in terms of Sharia law, then you mustn't charge interest. Okay, guys, that's it. It's bang on 10 o'clock. I thought I might go a bit quicker, but there it is, half an hour. I hope that was useful.
Thank you, Marius. I think that was quite a lot, and all I'm grateful for is that I don't do rentals, because I think it's a whole nother world unto itself.
Yeah, no, you need to understand exactly how it works.
Yeah, very complicated.
Great. I'm
But
going to let
thank
you
you,
carry on,
Marius.
guys.
It was
Thanks
a
for
great
joining me.
input.
Appreciate the support, and yeah, have a good day.